It's a morning of fun memories right here on TVC Breakfast Saturday, and it's been a groovy morning so far. We hope it stays so all through. Now to our next leg of discussion, and we still want to dissect the fallout of the presidential election petition court. Now, even though we're don't worry, we're going to bring you, so many, interesting perspectives. With us in the studio is Alibaba. Good to see you again, and I'm looking forward to what you have to say about the judgment of Wednesday.
The landmark judgment.
Landmark. All right. And then we also have a former president of the Nigeria Bar Association, senior advocate of Nigeria, Onweze Chukwujinka Joe Okocha, fondly popular as Okocha. Leonard Seal, good morning. It's good to have you join us.
Hello.
Good morning. I hope you can hear us. Good morning, Leonard Seal.
Yes, I can hear you. Good morning.
Thank you very much for joining us, Okocha. So let's begin in the studio. Alibaba is also here to share insights on what you took away from Wednesday's judgment. It was a hard-fought battle for the president, and with this victory, what was your initial reaction? What did you make of it?
First is to say that for the people who think that our judiciary is dead, judiciaries are weak. A lot of people had been talking about the eyes on the judiciary. Whether the judgment went in your favor or went against you, it still means that there was a ruling. And then there's still an option for you to go to the Supreme Court. But there was something that I think the Leonard Silk will need to speak to. It is the issue of someone interrupting a judgment.
It's not the first time we saw someone interrupting election announcements.
Oh no! An interrupting. It is nearly suicidal.
So even you take exception to that.
Oh yes. Oh yes. You can't. When a ruling is being read, you don't stop it.
You don't make a suggestion.
Exactly. You didn't just stop the judge. You then made a suggestion to the judge, like, I need to teach you a few things. So that needs to be done. And then I think our courtrooms are sometimes too crowded. And the judgment was rather long.
Detailed.
It was detailed, but rather long. I still believe that the points of law that were raised by the judges in coming to their judgment in the ruling is it's also a pointer to the fact that our processes for filing cases need to be amended.
Right.
We also need to finish off quickly with elections so that these things are done away with quickly.
All right, two quick things for us that you have said, and we want OCJ Okocha SAN to address that. The issue of interruptions during the judgment, as we saw on Wednesday, and Leonard Silk, the issue of the duration, more than 12-hour long judgment or judgments. Could you shed light on that? What should Nigerians know?
Well, let me say first, concerning the interruption of the judgments by the learned senior advocates, it's unheard of. Indeed, there should be absolute silence in courts when a judgment is being read. Most times, if you try to enter a court while a judgment is being read, you are prevented. Indeed, the police orderlies would stand at the entrance door of the court to prevent anybody entering the court. But here was an incident that happened in court, that a lawyer at the bar would stand up and say something to interrupt the judgments. And I think the justices, and particularly the presiding justice who was reading the judgment, was very, very correct to call him to order. It's unheard of. So I think that everybody should learn the atmosphere of a court indicates sobriety and solemnity, particularly when a judgment is being read. And when a judge is talking, even ordinarily addressing a counsel or addressing the courts, nobody should interrupt a judge. That is what we were taught, and that is what we practice. Now,
what about
the issue of the judgment itself? Yes?
Quickly help us address the issue of duration. More than 12-hour-long judgments on Wednesday.
Yes, that's what I wanted to go to. This is what we call a marathon judgment. It lasted for so long, and it was comical to me to see that some parties in court, indeed, inclusive of some counsel in court, were dozing off. But that showed you the depths of the research done by the learned justices and the painstaking nature of the work they did in producing that judgment, which I understand, someone sent it to me by WhatsApp, 700 and something pages. And what did they do by writing so lengthy a judgment? They tried to cover the field. They tried to review every issue that was in controversy and decide on those issues. So I commend the justices for a job well done.
All right, Honorable Leonard Silk, let's start with some of the issues, contentious issues that were addressed in the judgment. First, the case of Abuja not having the golden card. It's a case that many justices or many learned colleagues of yours believe was unnecessary. But of course, it was one of the petitions that petitioners brought before the judges. Do you think the judges were able to address that clearly for the avoidance of any kind of doubt? And the aspect of civil forfeiture not being a conviction, can you shed more light about that?
Well, let me say about that, and I did address a press conference on another channels, TV it was, 1 or 2 days before that judgment was delivered. Abuja, or the Federal Capital Territory, virtually has the status of a state. And the interpretation given by the justices who read this judgment of the Presidential Election Petition Tribunal, I agree with it in totality. Abuja has no special place that will make it what we call the determining factor of whether a presidential candidate has won an election. It is, you see, what I call a disjunctive term when they said 2/3 of the votes cast in 36 states and the Federal Capital Territory. Now, if you've won 2/3 of the votes in 29 states, there is no necessity to now consider whether the candidate who won or who was pronounced the winner scored 2/3 of the votes cast in the Federal Capital Territory. There's nothing special about the Federal Capital Territory. It does not hold what we call a casting vote. So I agreed entirely with the justices, and 2 days before this, and some days earlier, I had argued this with some friends and said, look, that's what we call a disjunctive interpretation of the word "and." Disjunctive. It's not always that it is conjunctive. So I agreed with the justices. Yes, I did agree with them. What was the other point you raised?
The other question was about the judges addressing one of the petitions involving civil forfeiture by the presidential candidate then of the APC, was one of the respondents, where they were asking about the forfeiture. And the ruling was that a civil forfeiture is not a conviction. Can you explain what that judgment really entails?
A forfeiture in a civil proceedings is just an order made for some money to be returned or to be forfeited. What will really indicate that a candidate has been convicted of an offense is a judgment from a criminal court. You follow? There had been all these rumors about, oh, the president was convicted, the president was indicted, the president was involved in some story about drugs and all that. The only way you can prove that is to produce a judgment of a criminal court that actually returned a decision that he was found guilty of the offenses alleged. This was not the case, and this was a distinction that the Presidential Election Petition Tribunal made, that forfeiture in a civil proceedings does not amount to a conviction for a criminal offense. So I agree with the justices, and I think they properly analyzed that matter and came to the conclusion which they did.
All right, Leonard Silk, Alibaba, you have some concerns.
So my concern, it's about certified true copies of evidence. It is hard to secure some of them, and we know how far a lot of these parties were going up and down with INEC to get certified true copies. Should agencies hold back when these copies are demanded by lawyers and for presentation in court? Because it can delay a case. If the Leonard Silk...
Did you get the question? Chief Onoha, did you get the question?
Yes, I think I did. I think my answer is clear and without any equivocation. Once a public agency is in possession of a document which is regarded as a public document, any interested party, indeed any person, can apply to that agency to give him or her or that agency, him or her, a certified true copy of that public document. It is there in the Evidence Act. And that officer will certify and then indicate how much was paid for the certification and also indicate when it was paid for. And then put a stamp with certified true copy marked on the document. So it's a responsibility for any public officer who is so demanded to issue a certified true copy to anybody who demands it. I don't know what was the issue here, what was not certified or what delay was caused in releasing those certified copies. Those are matters that were behind the scenes. What the court wants when a public document is in contemplation is for you to produce a certified copy of that document. And that is all that the law requires.
All right, Leonard Silk, let us quickly bring up a soundbite now that will help in our further questions on this issue.
Petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election.
That was Justice Monsurat Bolaji Yusuf of the Court of Appeal, who was part of the Presidential Election Petition Court, giving her own judgment. And don't forget that all the 5 justices gave unanimous decisions during that very, pivotal judgment on Wednesday. Leonard Silk, so there was the issue, I think, to build up on Alibaba's point about evidence, how, it is critical for you to aid the court and not leave it to the court to fish for you or fish for evidence, for you to build up your own case. But, now that all the parties have said they want to go on to appeal, Alibaba also has another concern.
Okay, so my concern is this. First is that the judges have said that you cannot make them be doing your work. You can't make the judges go do your work for you. But the other thing is, now that all of these issues are, because it was really detailed, just marks of the days of Oputa and Odili when they were in the court, Begore and all of them, their judgments were all very thorough and detailed. Now that this has been done, is there a chance for the petitioners to then go to the Supreme Court and say, they asked for this.
New evidence?
Yes, and say, these were the things they said we did not do in the last. Does that happen, or is that allowed? Because if that were allowed, it would look like the judges had given them expo to say, okay, now these are the things you didn't do.
Right.
Go to the Supreme Court and do that. Is that allowed? A new evidence is allowed to be introduced at the Supreme Court.
Let me say this, Alibaba. Is this Alibaba the master comedian?
Absolutely, live and direct.
What is answering me? It's him, Alibaba. Let me tell you, the appellate courts rarely admits fresh evidence. They only review what the courts that decided the matter, which we usually refer to as the lower courts, in this case, the Election Petition Tribunal. So it is at that tribunal that the parties have to produce all the evidence they require to prove their case. Now, while we say that election petitions are sui generis, that is to say they have their own peculiar characteristics, the rule of evidence still remains that any party who wants judgments with regard to its claim or petition has a responsibility to bring forward all the evidence he needs to prove his case. And if he fails, of course, the judges or the petition tribunal will say you have not proved your case. Further evidence will not be taken at the Supreme Court if they go on appeal, because all the Supreme Court has to do is to review the findings of the tribunal based on the evidence presented before the tribunal. It is only in very exceptional cases that you admit fresh evidence at the appellate level, because you have to prove that that evidence was available and could not be produced. That was why you did not produce it. And that is a very uphill task. So those going to the Supreme Court should not entertain any hope that before the Supreme Court they will now start producing fresh evidence or additional evidence. This will be rarely allowed. And in this particular case, I do not think it will be allowed.
Thank you. All right, Chief Okocha, of course, a respected legal luminary, and of course, Leonard Silk, former president of the Nigeria Bar Association. Let's bring this to you as well. The case of the eligibility of the presidential candidate of the APC then, who was one of the respondents, and the nomination of the vice president, the vice presidential candidate then, who is now the vice president, was one of the issues that was also addressed in the petition by the judges. They termed it as a pre-election matter. What are the lessons that political parties can learn from this judgment to forestall unnecessarily putting petitions before the courts all the time after they lose elections? Because many of the petitions were described as frivolous by the judges, but we will see another set of political parties come over and over again presenting these issues again before the court. So what would be your own legal counsel to political parties based on the judgment we received on Wednesday?
Well, my own position is that parties who seek to challenge the candidature of any other party's candidate should know that that is a pre-election matter. You follow? after a party has selected its candidate, no other party can interfere with that. Because you see, it is an internal party affair. But if there are issues concerning qualification of that candidate, concerning any allegations that the party is not even fit and proper to hold the office, those are pre-election matters that should be taken before the Federal High Court. And the Petition Tribunal made that point repeatedly and cited a lot of cases, because I was in my office listening to this judgment, that it had happened here, it had happened there, and everywhere. Candidates of a party are the entitlement of the party to select. And if anybody has any question about the qualification of such candidates, then that matter should be taken before the election, in fact, takes place. Because you see, if you are an APC, you can't challenge the selection of a candidate for the PDP, for instance, or the APC in this case, or what is it, Labour Party in this case. So again, I give it to the justices. They were quite correct in their decision on that point.